whether 73 is a civil penalty. This is the debate that is raging in the industry today. More so because the chapter where this section 122 stands starts with the word offences and penalties. And there are good arguments on both sides. There are good arguments on the side to say that the penalty under 122 is a criminal penalty, whereas 73 is a civil penalty. And the distinction needs to be understood. What is the criminal penalty and what is the civil penalty? You see, the distinction between civil law and criminal law insofar as punitive actions are concerned, the burden of proof, who needs to discharge it, changes. The criminal intent or mens rea, mea culpa, whatever else you want to say, the standard of proof needed to meet that is also different. In civil, it is preponderance of probability, potentially possible, if that's the view. Whereas in criminal, it is beyond reasonable doubt. So the test is different. For civil, the procedure prescribed under 73 would mean an adjudication officer will do that. Whereas for criminal, you need a prior approval of the commissioner before you can initiate the prosecution, and until that happens, you cannot invoke the penal consequences. That's a very fundamental difference, because then it would mean that there are two running on two parallel tracks. 122 being criminal in nature, which means that 122 to be able to penalize, you have to go through the whole trial process under criminal law, as meted out under the GST led with the CRPC, to say that there will be evidence collection, there will be cross-examination, there will be witness examination, everything else that goes into a proper trial that happens of an offence, because section 132, 134 contemplates that the process of trial will be carried out with the prior approval of the commissioner. Only then will the cognizance be taken by nobody less than a magistrate, and so on and so forth. And it could also mean that, going by PMLA in that sense, that the predicate of 122 could be 73. Because if a civil discharge has happened to 73, then probably automatically 122 ingredients may not be satisfied, and therefore it has to fall. So this is the conundrum that is troubling us in the industry, to say that whether 73 and 123 or 74, 73 and 122 are on the same page, one the criminal aspect, other the civil aspect, or they are two independent processes. One doesn't depend on the other. There is no concept of predicate in that sense. Now, from the revenue's point of view, or the state's point of view, I will not use the word revenue. Revenue seems like people are defending. I call it the state. From the state's point of view, what is emerging as their point of view is 122 and 73, 74 deal with two different aspects. 73, 74 is meant to deal with situations where you have not paid the tax, or you have claimed erroneous refund, or you have short paid the tax. That is the end of the investigation, that is the end of the matter for 73 and 74 to be invoked, subject of course to whether it was fraud, suppression or not. The period increases, the quantum increases. According to the state, section 122 deals with cases far beyond that. It is meant to deal with conduct which the Act does not expect you to do. It is on the conduct. It has nothing to do with tax evasion as such. I mean, it has nothing to do with tax exchequer loss. It is to deal with the conduct that leads to ultimate tax loss to the exchequer. For example, you have collected TDS and you have not deposited to the government. That's a conduct. That's a conduct that the law does not approve of. You have supplied services or goods without an invoice. That's a conduct. You have aided and abetted somebody in claiming wrong credit. That is a conduct. So, what 122 deals with are those myriad conducts that are not acceptable to the government, which has direct or indirect nexus or impact on the ultimate tax loss which 73 contemplates. But that is not to say that if 73 were to fall or 74 were to fall, 122 cannot stand on its own. They say that the word offense included in this particular chapter, penalty and offenses, penalty for certain offenses. Offenses by definition does not necessarily mean it has to be presumed to be always criminal in nature. Offenses can also be something understood as offending the charter, offending the very architecture of the statute of which they are creatures or of which they are taking advantage of. Merely because mens rea needs to be satisfied or proved, whichever manner, preponderance of probability or beyond reasonable doubt, does not mean that an offence is for sure a criminal offence. Even in civil cases, mens rea can be expected of. For example, and this is well known, 74 itself has an element of mens rea, fraud, suppression with an intent to evade payment of tax. That's all about mens rea. That's a subjective, fact-based, transaction-based, situation-based outcome. So the revenues or state's view on this is that 122 is an independent set of provisions that drives conduct, that tries to ensure that the conduct becoming of a taxpayer as expected under the statute is carried out, failing which an independent action will be initiated, and according to them, it is not necessary for you to conclude a proceeding under 73, 74 before you can access under 122. It is not necessary. One of the arguments that comes out from the assessor's point of view to distinguish between 73 and 122 is, as you recall, 73 uses the word proper officer. The show cause can be issued only by a proper officer. Whereas 122 does not have any jurisdictional fact or a jurisdiction imposed that it has to be only by a proper officer. It makes a blanket statement where so and so happens, penalty shall be levied. Who can levy? It does not predicate it, it does not qualify it to say that it must necessarily be a proper officer. So one distinction that one tries to argue is that look, they are two different things altogether. And therefore, if 73 is civil in nature, the sequitur of that is 122 has to be criminal in nature. That to my mind is also not a very fair reading of the law. 122 enables, confers the power, and if the power is conferred without stating out who can wield the power, then the presumption is every creature of the statute that the statute has created can wield the power, and if a proper officer has exercised jurisdiction under 73, 74, nothing stops him from exercising power under 122 because he is also a central tax officer under the Act. Now this issue was debated recently by the Allahabad High Court, and you would be very happy that the person, the learned judge who rendered the judgment was none other than a former friend of ours from our college. Both of us, Vipul and I, that junior to us, and a learned judge of the Calcutta High Court. This is Bobby Saraf. So Justice Shekhar Saraf has rendered a division bench judgment on this particular issue in the case of Patanjali. And I will give you the citation, you may wish to read that if you choose, which gives a very copious details on how he has very clinically analyzed the distinction between the civil consequences and the criminal consequences, and I thought it will be very topical for you to get into that. It's 2025 SSC Online, Allahabad 3235. The moral of the story, and as obtained from the decision rendered by the Allahabad High Court, he says that at paragraph 14 he says that offences, he says, is a transgression of law, infringement of a public duty. This is how he defines offence. Offence is a transgression of law, infringement of a public duty. It's a plenary sanction, may be there in a civil case as well as criminal case, and there is no necessity that it has to be there only in a case of a criminal case. So he makes it very clear that the word offences in that particular chapter, penalty for offences, does not ipso facto tell you that it has to be a criminal thing. It can be civil as well. And there are a whole host of judicial decisions that has been traced where the lordships have kind of dealt with it and have said that offences can also be of a civil nature. And he then defines the word penalty to mean something that embraces all consequences visited by law for any infringement of law. So he therefore says that it is not necessary that penalty has to be read in that context as a criminal penalty, it can be a civil penalty as well. The long and short of that, and I'm not getting into the correctness of this judgment right now, I'm not aware whether this judgment has been appealed or not, we don't know about it. Long and short of that is that we now have a jurisprudence which kind of clearly established that even if proceedings under 73-74 were to fall, it is not necessary that 122 proceedings cannot carry on. 122 proceedings is an independent proceeding of a civil nature carried out for violation of a certain pattern, certain set of conduct that the law expects you not to do. Once that is established, then you don't need to wait for any trial, etc. None of these are necessary. You can straight away proceed against the person in conjunction with 73. So you could have a situation where you have sold goods without payment of tax, sold goods without invoice, created loss of revenue to the government. Your tax liability, let's say, is 10 crore. In addition to 10 crore penalty under 74 in that example, because equal to 100% of tax, you can also be visited with 122 penalty, which could be equal to a certain sum that section 122 contemplates, and it specifically contemplates equal to the amount of tax. There could be a double penalty. Now, what is troubling me as a lawyer, a student of law, the offense may be optically different. Optically, you may say that 73 is about non-payment of tax, that is the offense. And optically, section 122 may be sale of goods without issuance of invoice, optically. But are they really dealing with two different subjects? They do not, to my mind, deal with two different subjects. 122 conduct is a means to the end which is lost to the exchequer, which is 73. So the means to create a loss to the exchequer was non-issuance of invoice with an intent not to pay the tax, and the consequence of the end is non-payment of tax. These are not two different things. I can understand non-payment of tax under 73 and collection of TDS and not deposit are two independent things. No difficulty there, because they really deal with two different subjects. TDS applies when you are making payment, you have an obligation, you are a custodian of the government, you are supposed to pay the tax forthwith. That's a different subject. But insofar as some of these 122 ingredients are concerned, and it will be instructive now, therefore, to have a look at what are those conduct that they have contemplated. Supplies any goods or service without issuance of invoice. This, to my mind, is nothing but a means to an end being non-payment of tax. Issues any invoice or bill without supply of goods or service are both in violation of provisions of that. This is like he was supposed to have issued invoice with a classification SSC code of 9974. He issues it with 9963, resulted the tax differential from 5% it has from 18% has come down to 5%, or 28% has come down, which has the resultant is loss of exchequer under 73. So it's a means to a loss of exchequer. Collects any amount of tax but fails to pay the same to the government. This is an independent thing, I would agree. Then fails to deduct tax, I agree. Fails to collect tax, I agree. Takes or utilizes input tax credit without actual receipt of goods. Nothing bad, having claimed credit under 73 without authority of law. So there are several of these which are a Siamese twin, or probably better put, that probably means to an end, to the ultimate outcome that 73 contemplates or 74 contemplates. And if that hypothesis be there, can there be a double dip? Can there be a double dip of a double penalty? Because that is when Vipul rightly mentions no penalty provisions have been challenged. I would say the penalty provision needs to be challenged. It is not a question of whether it should not be imposed or not, because the authority of law is there. 122 contemplates the imposition of penalty in addition to 73 penalty. But we need to ask this question, that whether 122 to that extent becomes draconian, exorbitant, confiscatory in nature, disproportionate to the effect that we are talking about, that you have collected the 100% of loss of the tax. You've done that, under 73 you can do that. You have imposed a interest under section 50, which is the compensatory part. The government has been compensated at rate that you have provided for. I have not decided the rate. Rate is 13% or 14%, I don't know, it's a very high rate, much higher than the bank rate. So having got compensated, restituted for the loss of revenue, the opportunity cost, having been penalized by paying equal to the amount of tax, what more do you want? You are extracting more blood than what you should. You are being, Shylock, beyond that. So the reasonability of 122 therefore needs to be challenged, as I would say it defeats the substantive due process clause. It is violative of the substantive due process clause, which is nothing but a manifestly arbitrary to my mind. It is a camouflage provision touted as a provision for penalty on an independent profile, but that is not the case. So some of these clauses of 123 which does not bear any nexus with 73, 74 may be kept apart. But the rest of the ones which probably are in coalesces up to 73, 74 needs to be challenged. And I think we have a good case there, rather than to say that I should not be liable under 71, 122. So that's my first point that I wanted to say. I've been conscious of the time. How much time do we have? 20 minutes, very good. So this was the first thing I wanted to talk about. The second thing I want to talk about is 69, which is your arrest provision. And this is something that I've been saying for some time now. I feel very privileged, proud, happy, satisfied as a lawyer that the day I hang my boots, probably I'll be able to tell, and I'm telling now, that I have had a hand to play in the evolution of jurisprudence on section 69, arrest. Before GST, the revenue authorities were aggressive, but not abrasive. There's a world of a difference between being aggressive and being abrasive. Their sharpness of their teeth dig and extract blood, but they were not as sharp as canine that we got to see in GST. What really happened was the unknown nature of the law, that GST as a legislative architecture, and the sweeping power that was made available under search, seizure and section 69 for the arrest came to be used by the revenue department as a tool of tax terrorism. And if there are officers here, I'm really sorry that I'm using such harsh and stark words, but it is born out of experience, it is born out of affidavits that the revenue themselves have filed before the Supreme Court in the case that I'm talking about. We have had situations where, in the name of tax investigation into potential tax evasion, companies, small or big, and of different hues, were made to fork out money without any show cause notice in the middle of the night. The DGGST, DGGI would make people sit from 10 a.m. in the night until 4 a.m. in the morning, and by midnight they would be so frustrated, and with the threat of arrest under 69 looming large on their head, they would all succumb. Because no businessman worth his salt would like a taint and incarceration that he had to spend one night in jail. Nobody does that. Money comes later. Life, liberty, prestige, dignity comes first. So Article 21 before Article 19. And resultant, the revenue also realized that this is a good force, good tool to extract taxes and not exact taxes. You know the difference between extract taxes and exact taxes? In our constitution, or the distinction between the jamidars of the back in the days and the constitution that we have is, today tax is imposed, no tax can be imposed without representation. That's a very fundamental thing. No tax without representation came from the American doctrine, which says that my obligation to deposit tax should not depend upon who the king is and his diktats. I and you, the people of India, will decide through our representatives what taxes I must pay and how. So tax through representation is tax through legislation. Who makes the legislation? It is people like you and I, through our representatives in the parliament. Tax through representation is all about a moral sanctity to exaction of tax. Extraction is when you are forcing somebody, apparently having the morality to collect tax, but without the due process of law. Because the due process of law is very, very fundamental. We are not living in a constitution where it's only a procedural due process that we talk about. Our constitution breathes today of substantive due process also after Maneka Gandhi. So A.K. Gopalan days, when they said it's only about procedural due process, has shifted to now substantive due process as per the American constitutional dicta. Maneka Gandhi and thereafter, R.C. Cooper and so on and so forth. So what has happened is, the revenue used that as a tool to kind of forcefully collect what they thought was tax without issuance of show cause notices. Large number of petitions were filed overnight, various high courts, and each of the high courts had to deal with this particular issue to say that can you at all collect tax without a show cause notice, merely on the basis of suspicion. That was the first point. Second was this threat of search that threat of arrest that would be kind of pinpointed and people would succumb to pressure, and in many cases they would actually get arrested as well. The problem that was happening in the architecture of GST, and which is what got rectified in the decision of Supreme Court that I said I was involved in. When a person gets arrested, more often than not it is based on a spot summon under section 70. He'll be called then and there. And after recording a statement, then and there will be an arrest memo that will be given to him, explaining the reason basis which he has been arrested. Once he is arrested, of course, you will go through the regular bail process, etc., which is not something that we are discussing. But it gets very difficult for you to show that the arrest was illegal. It gets very difficult for you to show that the arrest is illegal because who has arrested you? Very clearly the authorization would have come from the commissioner concerned, because prior approval of the commissioner is needed, executed by an officer below him who will give him an arrest memo. All the boxes are checked. So what I told the Supreme Court, what I argued before the Supreme Court is, the caveat in section 69 is where there is a reason to believe that so-and-so has committed an offense. What really happens is, this reason to believe is never shared with us assessors. So the Supreme Court said, why is it not shared? I said, it's a reason to believe, it's an internal document, it's a file record, and we all know as lawyers that anything that is in the file note can't be subject to challenge. Because certiorari will rely on an order, mandamus is on inaction, there is nothing else that you have, certified mandamus also does not apply to you, so what do you challenge? File notes can be challenged, and more often than not, file notes are not internal documents. How do I even have access to that? And somebody who doesn't have the wherewithal to have access to the department, he is in complete doubt. So then the judge said, then what should we do? I said, the best thing to be done is he should record his reasons, and that recorded reason should also be shared along with the arrest memo. So when an arrest is happening, not only the arrest memo, but the reasons recorded in writing with respect to the material which had a causal link with formation of his belief should all be there. And when the material and the causal nexus or the direct link with the formation of opinion is made available to you, then you can take that piece of paper, to the High Court for a secondary review. You understand the difference between secondary review and primary review? A primary review is when the court, constitutional court, gets into the substantive aspect of the application of mind and takes a view whether it was a right decision or wrong decision. That's a primary review. He steps into the shoes of the decision maker. A primary review, more often than not, never happens in a writ court. A primary review will always happen in an appeal court. So in an appeal court, a decision of the tribunal can be revisited, the evidence can be revisited, everything else can be revisited by the higher court because he's then doing a primary review. He's looking at the document as if he was the authority who was supposed to have decided it. A secondary review, which is called a Wednesday principle review, is all about the decision-making process. And it is here that the High Court can look at the material and to say whether the material could be said to have any nexus with the opinion that they came to. Was it reasonable view of the matter? Whether a reasonable man could have come to that opinion based on the material available, or was it based on suspicion, or was it based on hearsay, or was it based on some kind of a tip that he had but that is not available, on any material is not available at all. So the High Court will not go into the sufficiency of the material. High Court will go on existence of a material. High Court will go to the existence of a material and see whether the material was relevant for formation of a view. So if the material was, the person had traveled abroad, that may not have any nexus with the action that he needs to be arrested. But if the material was, there was a transaction that was not recorded in his books, but the bank statement are there, so on, so on, those could have. So if the application of secondary review, the relevant material is there, and the relevant basis, the relevant material, any reasonable man could have come to a conclusion that yes, this is a fit case for arrest, then judicial review will apply and the courts will intervene and interdict those actions. And therefore the legitimacy of the arrest can be challenged on that count. So today, after the Radhika Agarwal judgment, which is what I was talking about, today the law on this particular subject is not only do you need to show the arrest memo, but also the reasons recorded in writing must also be shared, so that the taxpayer concerned with the person who has been arrested can have adequate defenses available to it, to challenge or not to challenge whether the arrest was correct or in accordance with law. This to my mind is an evolution, this to my mind is a tectonic shift from the time when the GST law was kind of rolled out 8 years back. And I don't get to see too many arrest news these days, except for those people who are doing actually bogus transactions. I don't see too many multinational companies being served with Section 70 spot notice and say, pay order, otherwise I'll arrest. And it forced the CBC to also issue directional statements that don't use this arrest as a tool. It gets too draconian and the image of the department kind of gets tarnished. So that's the second point I wanted to talk about insofar as the prosecution arrest is concerned. And the third thing I want to talk about is the burden of proof. You see, the burden of proof is a very difficult and a very complicated subject. Under 73, 74, because these are civil offences, if there is an allegation that there is a suppression, there is a misstatement, then the burden of proof is on the revenue to prove that there is a suppression. The revenue will have to show that these are the 30 reasons why we believe there is a suppression and mere allegation will not do. And you as the taxpayer have the defense available to deal with each of those reasonings that they are provided for based on material availability. So the burden has to be discharged by the revenue. But the moment it goes to criminal prosecution, the burden of proof is completely otherwise. It's like an NDPS, where you are presumed. It is on you. You need to prove your lack of mens rea. And therefore you will have to go, if you are not able to discharge that, the revenue has had a field day. He doesn't even have to open his mouth. So ability to discharge your burden shifts depending upon whether it's a criminal offense related provisions that are initiated under section 132 said with section 134, whereas the burden of proof is on the revenue when it comes to section 73 and 74. So that's a very important and interesting aspect which I thought I'll share. I think time's up. Thank you very much for inviting me, and I hope you have a great pujo coming in the next couple of weeks. Thank you.
request Chairman sir to please some appreciation.
ঠিক আছে এসো কোন দিক দিয়ে লাইন যায় না দুটো স্নান কিছু এসো এসো
As I had already warned, Mr. Ghosh will speak a lot about a lot of things on penalty, and he has been very educated. Three aspects he dealt on with regard to civil and criminal in nature, whether the penalties, both kinds of penalties can coexist. Mr. Ghosh has raised the point that there should be a challenge on this. But this is, according to me, age-old. If you see FERA, it was there. Customs Act also has it. GST has it. In particular, if you go into the Customs Act, the penalties under 114 coexist with 114AA. Similarly, 73, 74 coexist with 122. So it's not something absolutely new that has come in. Penalties on strict liability basis is one thing. Penalties where fraud, mensia are required are another thing. Both kind of penalties, in my humble opinion, probably can coexist. Therefore, it's a very arguable point, and this should be looked into and dealt upon. And further discussions on this point are extremely required, and it's a serious aspect of the law on penalty in GST. The second point, he has dealt upon is section 69. Again, the concept of arrest is nothing new. That is there in GST. It was there in all, it has been there in all these acts. These have been challenged for, and it has been now challenged in the GST Act. And fortunately, in the Radhika Agarwal's case, certain specific aspects have been decided and safeguards have been given which have to be followed. But the moot point, the third point is again burden of proof. He also wanted to delve into the aspect of burden of proof. Unfortunately, because of paucity of time, we have missed him speaking on the aspect of burden of proof, which is also very important. He says 73, 74 doesn't, the burden of proof is on the revenue, whereas under 32 burden of proof is not on the revenue but on the assessment. I beg to differ on that. In fact, in criminal jurisprudence, it is always burden of proof is on the prosecution, and prosecution has to prove. The degree is much higher in criminal prosecution than it is on usual adjudication proceeding penalties. Nevertheless, I would have really wanted Mr. Ghosh to enter into that point of burden of proof and how this is different in this GST Act. Maybe we'll get another to discuss this aspect, but overall, I feel that penalty aspect that is there in GST is not something new. The civil aspect of it as well as criminal aspect of it are there, have coexisted in other statutes and will coexist in this statute also for a particular reason. As Mr. Ghosh also mentioned that who makes the law? The law is made by us, our representatives. Who gains from this law? Or who is burdened by this law? It is us, as the public. But here, as professionals, how do we advise